What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are going to be talking about one of the most obvious illustrations of judicial bias I have seen in a long time. It is comparing apples to apples, and I find it hard to believe that it was this obvious and not even trying to hide it at this point. And yes, we're talking about Judge Cannone in the Karen Reed case, as Dr. Crosby is allowed to testify as an expert. And it's not even the fact that he's allowed that makes me feel like this bias is coming through loud and clear. We're going to compare these two orders and explain exactly what I see and why I see it this way. And feel free to let me know if you disagree. So if you remember back to the video I did, I don't know if it was yesterday or the day before, it's all kind of running together at this point. I expected Judge Cannone to allow Dr. Crosby to testify as an expert in dog bites. Not because I thought he was qualified, not because I thought he even explained what his methodology was, just because I know, practically speaking, what judges do in these situations. Once they allow an expert on one side to testify about something, to me, they're more likely to allow an expert on the other side, especially when one side objects, has a Daubert hearing, asks all the questions, makes these arguments, and she says it's a close call to allow them to testify. It's likely that as long as somebody can even pass the smell test, which some would argue he can't, that person's going to be allowed to testify. I saw some people making jokes online, asking a ton of questions about this. I guess I have a dog. I guess I can testify as a dog bite expert as well. And sometimes it feels that way when it comes to experts. And I would say he probably has a little more experience in that, but barely. And he definitely did not fully explain the methodology. But here we are. Let's read through the judge's order and compare it to the order on Dr. Russell to show just how bad and obvious the prejudice comes out when it comes to this decision for Judge Cannone, and how she is so far prosecution leaning when it comes to making some of these decisions. And she's not even trying to hide it at this point. Sometimes I think she's been even handed. And you guys know, I try to be a straight shooter. I call it like I see it. If I think she's being fair, I'll be like, yeah, this seems fair. If I think there's an obvious bias here and I don't understand why she does some of the things she does, and you can go back and check the tape on what I said when Dr. Russell's order dropped that she was going to allow her. But what Judge Cannone said blew my mind. And this is giving you a good example why. So let's take a read here of the order. The decision and order on defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby, MS, PhD. After hearing and review on the pleadings, the court finds the Commonwealth has satisfied the foundational requirements of Daubert-Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony, principles, and methods employed are reliable. What are those methods? The defendant's objection goes to the weight of the evidence, not the admissibility. The defendant's motion to exclude the testimony of James W. Crosby is hereby denied. No surprise there, really. Frankly, this is a very common order that a judge would file in a situation like this. And when we talked about Dr. Russell's testimony and how she allowed that, this is the order or the type of order I expected. You guys made some good points, but it goes more to the weight and not the admissibility. Therefore, we're going to let it in, and you guys go ahead and hammer it on cross. That's what I expected, but that's not what we got. Frankly, with Crosby, she didn't say it was a close call. We didn't even have an evidentiary hearing. The defense didn't get the opportunity to have a free cross-examination shot at Dr. Crosby, which they absolutely asked for. They asked for him to be struck, but if not, at least an evidentiary hearing. He said, I don't think we need an evidentiary hearing because this is so obvious. And the judge took it a step further. Having no shame in her game, like, we don't even need an evidentiary hearing. This is so not close. He did it. And if we go back and read now Dr. Russell's testimony, or the order allowing Dr. Russell to testify, I think we figure out why Judge Cannone doesn't think this is a close call and how she would compare these two experts and the evidence they're going to testify to. So I found this comparison here on Brandy Churchwell's Twitter, and she does a really good job with the documents and following these cases. And it was easy for me to just kind of pull them up back to back here. And she's right in explaining how different these two orders are. So let's take a read now, a second time through Dr. Russell's allowance. Memorandum, decision, and order on the Commonwealth's motion to exclude the testimony of Dr. Marie Russell. By the way, 3 pages versus 1 paragraph. 3 pages. By the way, very clear to me, she's a much more qualified expert and actually does have methodology that Dr. Crosby put in his papers for, I don't know, his master's, his PhD, whatever it was, when he didn't even talk about his own. It's neither here nor there. And I'm not even comparing like who's the better expert. right? Because this is purely apples to apples. These experts are very different people, but what they're testifying to is the same. They're testifying on the same expertise. So this is apples to apples as you can possibly get. This is the battle of two experts, and look at how differently she handled these orders. First off, she made Dr. Russell come and have a hearing, an evidentiary hearing, not Dr. Crosby. Before this court is the Commonwealth's motion to exclude the proposed expert testimony of Dr. Marie Russell. Dr. Russell intends to testify as to whether the abrasions on John O'Keefe's right arm were caused by a dog. The Commonwealth contends that the defendant has failed to show that her testimony meets the requirements set forth in Daubert. The court conducted a Daubert-Lanigan hearing on December 12, 2024 and January 7, 2025, 2 days. Although a close question, the court will deny the Commonwealth's motion. So Dr. Marie Russell was a close question, a close call. She put it in her order, not Crosby. Crosby, not a close call. It seems so obvious that it should be flipped, but even if it wasn't, this is why judges should just write orders like, I'm going to allow it. This goes to the weight, not the admissibility. That's what I would have expected from Dr. Russell. That's what I expected. That's what I would have expected on Dr. Crosby. If she would have just written the same order, then nobody could be able to say, this is so obviously biased. You could be annoyed that she let Dr. Crosby in, but it's really not that unusual for judges to do that. But to do it the way Judge Cannone did it is incredibly unusual. Here's the discussion. Before a witness can provide expert testimony, the court, as the gatekeeper, must make a preliminary determination that the testimony has satisfied the requirements for admissibility. Expert testimony is admissible when the testimony concerns matters beyond the common knowledge of the jurors and will aid the jurors in reaching a decision. She simply said the testimony will help the jury in Crosby's order. Expert testimony is inadmissible, however, when the witness testifies to matters beyond her area of expertise. The determination of admissibility is within the court's discretion. However, before the court may exercise its discretion to admit expert testimony, the party seeking to offer the testimony, here the defendant, must establish 5 foundational elements. 1, that the expert testimony will assist the trier of fact because the information is beyond common knowledge of the jurors, which is exactly why I think the whole meteorologist is totally unnecessary. That prong. We can just have lay people talk about how hard the ground is. We can have lay people and the videos show that it was, in fact, snowing and what the temperature was at the time. Why do we need a meteorologist to tell us that? Neither here nor there. Number 2, that the witness is qualified as an expert in the relevant area of inquiry. Number 3, that the expert's opinion based on facts or data of a type reasonably relied on by experts to form opinions in the relevant field. 4, that the theory underlying the opinion is reliable. And 5, that the theory is applied to the particular facts of the case in a reliable manner. Simply answered that in, one line on Crosby. Here, the recognition of dog bite wounds is not within the common knowledge of a layperson and requires expert testimony. And Dr. Russell is a qualified expert as to these topics. She is a board-certified emergency medical doctor with over 30 years of experience, is trained in forensic pathology, and has conducted over 500 autopsies. I would have liked for her to give us the explanation, the long explanation about why Dr. Crosby is such a qualified expert. I would have really liked that. I would have liked to read it. With respect to dog bites specifically, Dr. Russell has treated hundreds of wounds resulting from dog attacks during her time as an emergency room doctor and co-authored peer-reviewed articles on the treatment of law enforcement canine bites in the emergency room. Lastly, in forming her opinion in this case, Dr. Russell conducted a differential diagnosis based on the pattern of the victim's wounds and their characteristics and supported her theory with references to peer-reviewed publications. Use a differential diagnosis is a standard scientific technique of identifying the cause of a medical problem. Accordingly, the court finds that Dr. Russell's testimony satisfies the 5 foundational elements and therefore will allow Dr. Russell to testify as to whether the abrasion on John O'Keefe's right arm were caused by a dog. I wish we would have gotten that explanation on Dr. Crosby, don't you? How would she have explained it? What articles did he rely on? What was his methodology? How reliable is that? What experience does he have in identifying dog bite wounds? In so ruling, the court recognizes that on cross-examination, the Commonwealth demonstrated, among other things, that Dr. Russell's expertise primarily concerns the treatment, not the identification of dog bites, that her evaluation of the abrasion failed to consider all available information. So she's pointing out and highlighting the negatives or weaknesses or shortcomings that she sees in Dr. Russell's testimony. She didn't do that for Dr. Crosby. Wonder why? This is where, to me, it feels like obvious bias. This was an unnecessary paragraph. I said it at the time. It feels even more unnecessary now that we've read Dr. Crosby's order. But here's where we highlight that she actually thinks Dr. Crosby's more reliable. The way he did it is better. He included more facts. And this is exactly the problem. As if it were to go to a jury, the jury's not going to hear that Judge Cannone feels this way, but you can understand how a reasonable juror, when comparing these two, may think Dr. Crosby's actually better than Dr. Russell, even though scientifically and the reliability wise and methodology wise, that's clearly and legally not true. But why does Judge Cannone think there's an issue with Dr. Russell and the way she did it? Well, she has not compared the abrasions with the dentition of the German Shepherd in question. Well, there's a reason she didn't, but she thinks that's a good idea. And guess who did do that? At least purportedly, Dr. Crosby. And that her opinion is inconsistent with findings that there was no canine DNA in the area of the victim's clothing near the abrasions. So clearly she thinks Dr. Russell is wrong, but just because she had a wrong conclusion doesn't mean she's not going to let her testify. But guess who did include that and would say that their opinion is consistent with no canine DNA in the area of the victim's clothing of the abrasions, whether or not factually we agree with that? Dr. Crosby. However, the court concluded that these issues go to the weight of Dr. Russell's testimony, not the admissibility, and can be addressed during cross-examination at trial. So how about that? She said the last part about Dr. Crosby too, that goes to the weight, not the admissibility, which is totally normal. But to highlight what those issues are with the weight and why maybe this isn't credible, why maybe a jury shouldn't buy what Dr. Russell is selling, she highlights it for the world to see. And I'm sorry. I do my best. I do my best to give people the benefit of the doubt, but this is so obvious. I want to hear what you guys think if you disagree with me respectfully in the comments. Let me know why. Let me know where I'm wrong. Let me know where I'm off track. Please let me know. And this is not about whether Karen Read is guilty or innocent. That's not what this question is about. This is a simple legal question applying the same standard to two different experts with the same purported expertise. You can get there different ways. The whole medical doctor thing, I know people want to make jokes about it, and that's fine. She doesn't create the legal standard with her comments. She can be wrong as a judge. So I am not overly shocked that she's allowing Dr. Crosby to testify. But the way she wrote these orders, there's just no way, no other way to call it, in my opinion. That's how I see it. But let me know what you guys think. Hit the like button if you enjoyed the video. Make sure you're subscribed to our channel. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.